Florida estate litigation and civil contempt. Can you be held in contempt of court if you don't know what you were supposed to do? Hello, my name is John P.L.L.C. I'm a trial attorney who handles probate and estate litigation in West Palm Beach, Florida. I practice with the P.L.L.C. law firm in downtown West Palm Beach, Florida. We're a group of trial attorneys who handle disputes, trials, and appeals involving wills, trusts, estates, probates, business and commercial litigation, as well as guardianship matters. There's a lot of contested guardianships in Palm Beach County these days, and as well as litigation involving life insurance contracts, bank accounts, financial accounts, real estate, and homestead. So if you're involved in an inheritance lawsuit in Florida or estate litigation in Florida, you need to be concerned about contempt. Why? Because when probate court judges enter orders, when they command you to do something or refrain from doing something, if you don't follow the judge's orders, you can be held in contempt of court and bad things happen. Why do I mention contempt of court in the context of estate litigation? Because in estate litigation, there's a lot of family emotions, there's sibling rivalry, there is discord and disagreement or disharmony. Sometimes you may be the stepson or adult daughter or son of a mom or dad who has a second or third marriage and you don't get along with your stepmom or stepdad. By the same token, you may be an ailing or an elderly mom or dad, and you have a very close, loving relationship with your second, third, or fourth spouse who's about to be a widow, and you're not seeing eye to eye, or you're having disagreements with your adult children from your first marriage. Very emotionally charged matters in probate and estate litigation, and sometimes people don't behave. Well, our justice system in Florida, our judicial process in civil procedure, requires that we follow court orders. Those are our rules, right? We're a civilized nation. We don't take to the streets. We don't get into fights. We come into court. We're civil, we're articulate, and we let the person with the black robe, the judge, decide things because we're civilized. So if you're involved in estate and probate litigation and a contempt order has been entered against you, do you know your rights and do you know if that's appealable or not? Can you appeal a Florida contempt order, and do you know what the standard of review is? Well, there's a 2015 case from November 6th out of Florida that speaks to civil contempt. The case is Menke, M-E-N-K-E, M as in Mary, versus Wendell, W-E-N-D-E-L-L. The site is 2015 Westlaw, W-L, 677-7225. This is a Second District Court of Appeal from Florida case. And the appellate opinion is not a probate opinion, but it does deal with the issue of civil contempt. Here's some things you need to know about civil contempt in Florida. Why? Well, if a motion for civil contempt has been filed in your litigation, you better know how to respond to it. Two, if you've been ordered to do something, or there's been a command issued by a probate court judge in your Florida estate litigation, you better know how to comply with it, and you better know what that order says. In this Menke case, evidently the party was not clear on what the order said. And the Second District Court of Appeal speaks to that particular situation in the context of contempt in Florida. So you can ask any Florida probate lawyer or an estate litigation attorney in Palm Beach or Florida, and they'll tell you that contempt is very serious. When somebody files a motion for contempt, everyone perks up, right? It requires a thorough analysis and a response. In addition to that, when a judge considers contempt a violation of an order, serious things or bad legal things can occur. So the Second District Court of Appeal noted that prejudgment civil contempt order that's entered is subject to a certiorari review by the Florida Appellate Court. The applicable standard of review, right, this is what an appellate court will consider regarding an order of contempt from a Florida trial judge. The standard of review is whether the challenged order is a departure from the essential requirements of law, causes material injury throughout the remainder of the proceedings or the trial, and causes injury that is irreparable, okay, as it effectively leaves no adequate remedy at law. So that's the standard of review that a Florida appeals court is going to consider when a motion of contempt is granted, or I should say when an order of contempt is entered against you. Now, it's well established that a party cannot be sanctioned, right? You cannot be held in contempt for violating a court directive or order which is not clear and definite as to how a party is to comply with the court's command. okay? And that's the case, or those are the circumstances involved in the Menke case, right? If you violate a court order and the other side files a motion for contempt against you, and the judge has a hearing, there should be an evidentiary hearing with findings of fact, with testimony, with evidence. And if you are found to be in contempt, the other side can move for sanctions, or the court at any time on its own can sanction or punish bad behavior. A trial court, a probate court in Florida has an inherent right to do that, to sanction bad behavior. So these are the standards of review. If a contempt order has been entered against you and you don't know what to do, it's not clear, you should go in front of the judge and ask her or ask him what he or she meant by the order so that you can comply with the order. You shouldn't do nothing, right? You shouldn't do anything. You should ask the judge, you issued an order, here's a command, I don't know what it means, tell me what it means because I want to comply with it. I don't want to be held in contempt and I don't want to be sanctioned. In this particular instance, the appellate court said that a party cannot be held in contempt if you don't know what you were supposed to do to comply with the judge's command or the court order. And that's very important. So this concludes my remarks on Florida probate litigation and the issue of contempt.